Call the meeting to order. Good evening, everyone. Time now is 7:33 p.m. This is the meeting of the Municipal Land Use Board of the Borough of River Edge for Wednesday, March 11th. I realized I don't have you have the open public.
Yes. This meeting of the Municipal Land Use Board of the Borough of River Edge is being held both in person and remotely via Zoom in compliance with the provisions of the Open Public Meetings Act and associated regulations. Notice of this hybrid meeting was published in the Bergen Record, posted at Borough Hall and posted on the borough's website. The notice included the dial-in login information necessary for public participation and access to this meeting remotely. Copy of the agenda for this meeting was made available on the borough's website near the posting of the meeting notice and included the dial-in login information. Please silence all cell phones during the public comment period of this meeting. If you'd like to make a public comment, you may step up to the microphone and wait to be recognized by the chair. Press the raise hand button on Zoom or dial *9 on your telephone keypad to raise your hand. You may mute and unmute yourself by pressing the microphone icon on Zoom or dialing *6 on your telephone keypad. You must state your name and address prior to making a public comment.
Okay, thank you very much. With that, I ask everyone to please stand. Mr. Salvo, would you lead us, please?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Everyone, before we get started, one housekeeping note, we will have a curfew this evening of 10 p.m. Okay. At this time, we're going to ask that we call the roll, please.
Yes, thank you. Mr. Mayor?
Here.
Mr. Caslin?
Here.
Mr. Cray?
Here.
Ms. Boland is absent at the moment. Mr. Gibbons?
Here.
Mr. Canigo?
Here.
Mr. Salva?
Here.
Mr. Gautier?
Here.
Councilman Glass is excused. And Ms. Levine.
Here.
Also present, we have via Zoom, our zoning officer, Mr. Depkin, our in person, our board planner, Mr. Behrens, our board engineer, Mr. Costa, and our conflict counsel, Ms. Federico.
Okay, thank you very much. Our first agenda item this evening is under approval of minutes. We have a set of minutes from our meeting of January 28th, 2026. Draft set was circulated to the board for review prior to this evening and open it to the board for comments or questions on the draft minutes as presented.
Oh, I had made some edits that I will share with Lisa. Just that the noting down who made the motions for the approval of the minutes, for the January 14th minutes, and then the memorializations that occurred at the January 28th meeting, and then just a few little typos, but everything else was the same.
Okay, with those changes, look for a motion to approve the minutes.
So moved.
Thank you, Mr. Curry. Is there a second?
Second.
Thank you, Mr. Gibbons.
And everyone is eligible except for Mr. Mayor and Mr. Caslin. So we can do a voice vote.
Okay. Those abstentions noted. All in favor?
Aye.
Any opposed? Okay, thank you very much. We do not have minutes at this time for February 11 or February 25, so we will continue on our agenda under discussion items. We have our master plan consistency review of a proposed amendment to the zoning ordinance. Mr. Barnes.
I think you have to press and hold there's a button on the top of the microphone, just till it turns green.
Oh.
I didn't check that one.
Yeah, it's illuminated.
There we go.
Can you hear me now? Okay, all right. Good evening. Do I need to be sworn? No, it's not a public hearing.
No.
Good evening.
Well, you've been previously sworn and you're still under oath.
I'm Barron's last name, EPH, RNS, plan for Merchants Associates. We've assisted the borough addressing its board-ground housing obligation. As part of that process, the state has required that municipalities adopt all implementing ordinances no later than March 15th of this year, so just a few days away. We are right on track to comply with that requirement. So the council previously introduced several ordinances that are mentioned in the town and boroughs housing element fair share plan. One has to do with amending several of the borough's existing affordable housing sites, as well as the creation of 2 new affordable housing overlay zones. I suppose I should start with that ordinance first. So again, this ordinance amends the borough's existing zoning ordinance. One, it amends the borough's existing New Bridge Landing train station redevelopment area by simply increasing the maximum permitted density there in accordance with the borough's mediation agreement to the fair share housing center. The second has to do with increasing the density at what's referred to as the Affordable Housing 1 overlay zone, which encompasses the site, which includes the existing BP gas station, the existing golf simulator facility, as well as the plant retail store on New Bridge Road. That existing ordinance will remain intact. Again, the only change there is an increase in density. The third change to the existing zone has to do with the borough's multifamily and senior conditional use district, which is on the east side of Kindercanack Road between Howland Avenue and Reservoir Avenue. There is no change to the actual zoning. There is just a change to the minimum required affordable housing set aside, where the borough, like most other municipalities in the Fort Brown, have required the for all rental projects that they've the affordable set aside has been increased from 15% to 20%. And again, that's an increase that we've seen sort of uniformly applied in municipalities across the state. And then finally, there are 2 new affordable housing overlay zones that are being created. One is at the north end of town, which is being referred to, I believe, as the Affordable Housing 3 overlay zone. And just to be clear, what an overlay zone means is that the underlying commercial zoning will remain in place, but the overlay zone creates a new optional zoning framework, because the borough is responsible for creating the opportunity, not to make the development happen or select the developer, but to create the opportunity through zoning. And that site essentially encompasses the existing Riverdale filling station and adjacent Verizon property. It creates the condition where the site can be developed with either multifamily or mixed use framework. I believe that 15 units per acre. It maintains the height that's sort of described in the underlying commercial zone. And again, there's a new overlay zone as part of the settlement agreement, Fair Share Housing Center. And then finally, the new zone that's being created at the south end of town essentially exists on the south side of Route 4 with frontage on Johnson Avenue. That site would allow for multifamily development, it's up to 4 stories and 40 units per acre. In recognition that that site presents a redevelopment opportunity that was identified through the state's meeting process with Fair Share Housing Center. So that's a summary of the ordinance changes with respect to site-specific affordable housing sites. I'll note that all of them are specifically identified in the amended housing element fair share plan that this board adopted at its last meeting. And by virtue of being included in that plan, I would offer that that ordinance is specifically or substantially consistent with the borough's housing plan. It also promotes the borough's goals of improving sites that are in need of redevelopment, as well as providing for diverse housing. So the task for the board, you want to break it down ordinance by ordinance, or okay, so pausing on that ordinance, the task of the master plan consistency review for the board is 1, to identify any provisions of an ordinance that are deemed to be inconsistent with the master plan in any way, and also you can offer any recommendations from the mayor and council. So subsequent to this master plan consistency at the council meeting tomorrow night, presumably these ordinances will be adopted and go into effect.
Okay.
And I think it's just one consolidated ordinance, even though it's doing all of those things that Tom
For the
described.
development ordinance, there is 1 or 2 other. There's the general affordable housing ordinance, as well as the development.
But the only one that we're reviewing for consistency is this one. But yes, but there are other related ordinances that the borough is going to.
Brown is correct. The board's focus is on this.
Okay, thank you, Mr. Barron's. Questions from the board? Comments?
So we would just need a motion that the ordinance is not inconsistent with the master plan.
Okay, I just have a couple of small edits from what we've seen before we take a motion. There's reference in the third and fourth recitals to the River Edge Planning Board. I think just the technical change, it does refer to us as the Land Use Board later on, so we just need to change in those couple of places, place else that happens to appear. So with those minor edits, I will look for a motion to deem the ordinance not inconsistent with our master plan.
So moved.
Thank you, Mr. Cody. Is there a second?
Second.
Thank you, Mr. Kenigo.
All right. Mr. Mayor,
Yes.
Mr. Caslin,
Yes.
Mr. Cray,
Yes.
Mr. Gibbons,
Yes.
Mr. Kenigo,
Yes.
Mr. Salva,
Yes.
Mr. Gautier,
Yes.
and Ms. Levine.
Yes.
Okay, the motion passes.
Okay. Thank you very much. At this, we have nothing under memorialization this evening. So at this time, going to ask for a brief recess to allow the mayor to depart and just to organize ourselves for the rest of the agenda. So can I have a motion we'll adjourn, it's 7:45, take a 5-minute recess. Have a motion,
moved.
please. Thank you, Mr. Cray. Second,
Second.
all in favor?
Aye.
Any opposed, any abstain?
Thank you all.
See, I try to do it first thing in the morning, because I can't do it at night. It just doesn't work.
Me too.
I gotta be there.
Or I'll go right after work. You know what I mean?
Even
Right after.
Yeah.
If I wait until like now.
We go, I was in the city, it's like, I don't want to the city, so
Okay.
it's smaller. Not as many. I mean, it's okay.
Let's get started. I'm gonna call the meeting. Reconvening the meeting. It's now 7:48 PM. Good evening. Just call the roll quickly.
Chair Castle,
Yes, here.
Michael Cray,
Here.
Eileen Boland, absent, Brian Gibbons,
Here.
Terrio,
Here.
George. George, Salvia,
Mr. Talbot.
Salva, Mr. Salva,
Here.
Joseph Gutierrez,
Here.
Tracy Levine.
Here.
Okay. And for the record, we have our planner, Mr. Barons, our engineer, Mr. Costa, and on Zoom is Mr. Depton, the zoning officer.
Good evening.
Good evening. All right. At this time on our agenda, we're going to move into the completeness review section. For an application, the applicant is Pacific Outdoor Advertising LLC. Property is 14 Route 4 West. This is block 1402, lot 4. Application seeking preliminary and final minor site plan approval with use, height, and bulk variance relief to install and operate a two-sided static billboard. We'll turn to our council and
So we did review the notice that was published and mailed, and it was sufficient, so the board has jurisdiction to hear this matter.
thank you very much. Mr. Barons.
Good evening. If you want to sit down, I'm going to just go through a couple notes and then we could talk about it. I think that's
Yeah,
probably a
we'll
good way
come
to go
back.
about it.
We'll do completeness first, then we'll come back to you.
So we're just merely reviewing completeness, and as far as I understand the application, it's for the installation of a billboard and no other site improvements. So my review will be based on recognition of that fact. So I'm just going to identify what I believe are technical waivers that the applicant should probably request and the board can consider, again, in light of the nature of the application. Which included in the submittal, the application forms, supplemental information, as well as a revised site plan and property survey, I believe. And so as far as completeness items, just identifying, rather questioning some of the checklist items that I'm not sure whether or not they're applicable, or if they've been provided. I'll list them and then give the applicant an opportunity to respond if that works. Okay. So the first being just an accurate description of existing and proposed uses. That'd be one. The second pertaining to, and this is just literal technical compliance from the checklist, pertaining to the size, location, parking bays, and aisle dimensions. So while I recognize this is for a billboard, I believe the site has some existing non-conforming conditions, which may pertain to the parking area. The second is the location and direction of all illumination and time of proposed outdoor lighting, including all standards and utility poles. So recognizing that they did submit a light study, but I don't believe that light study has property lines. So whether at some point, I think it'd be expected that they provide that level of analysis so we can ascertain whether or not the foot candles at the property line have been are conforming. Bear with me while I go down my list here. We addressed the use thing. This is similar to parking. This is just reference to the number of parking spaces for the uses. Again, I fully recognize the billboard does not generate parking. It looks like part of the base might or might not impact the existing parking area. The applicant identified that Bergen County site plan is not approval. Approval is not required. I don't know the answer to that, so that's just a question for the applicant. Again, number of parking spaces required and provided. One technical compliance matter has to do with the depiction of topography within 30 feet. I'll note that no landscaping is proposed where landscaping plan is technically required. Fully appreciating that it is a billboard application. No plans for the existing building, which is not proposed to be improved at all. And that's it.
Right. So with those,
So those are the items that I believe either may not be applicable or have not been submitted. And I think the applicant technically has to request a waiver, and the board would then, it's the board's discretion whether or not to grant the waiver to determine the application complete.
Mr. Costa?
Again, I don't know if you want to go one by one, what Tom just said, but that's probably the best of the boards.
That's fine. We could do that too. I was gonna give everything on the table, but that's preferable. Okay. Just go around the, Mr. Salva, we'll start with you.
No comments.
Okay. Mr. Codier?
No comment.
Mr. Gibbons?
No comments.
Mr. Good? Mr. Ego? Ms. Levine?
No comment.
Okay.
That's how I would go for it. So basically what my recommendation,
You need to clear your microphone.
not used to coming to the big table. What I would do, Mr. Chairman, other boards that I represent, if you want to talk about completeness, you go through the checklist, which if we weighed this, it would be a couple of pounds. There's X's and there's check marks. And I think what Tom just brought up is the stuff that they requested, not applicable. So you can go through it one by one. You can certainly do that. My recommendation is say, and then the board could say, we want that information, you're incomplete, or you can provide it at a future point and we can go forward. But again, it's up to the discretion of the board. And it's up to the applicant to request it and let him put his arguments on the record.
Can I guys speak on the
You
issue?
can speak on it.
Yes, thank you. As far as some of these items will certainly be addressed during testimony. We do, I believe we will request a waiver at this stage, but we do believe we'll be able to answer most of those questions through the testimony of the experts here tonight. And I know some of the issues, I think there was just maybe a misunderstanding about the current uses of the property. I believe we did disclose it's 2 office buildings being utilized there. And the parking and issues we have a plan. I don't believe the parking may be striped, but we'll have testimony from the engineer as to that.
Well, what is there to the chair? From my understanding, it's an architect.
An architect and is it like a
It's astrology.
yeah, astrology? I don't really.
The reason the question was raised, and I did raise it as an item to be confirmed and whether or not it is because one of the forms in the application packet had a signature of a name that resides at the property.
He is the owner and his office is there.
So nobody lives there.
He doesn't live there.
I would just casual observation that there are at least 2 vehicles that tend to be there at all hours of the day, almost every day. And that's just a casual observation. So I mean, put it on the record because it's not permitted that there's no residential use there.
Do you have that information available?
I believe the engineer can testify to it too, but the owner is not here and I don't believe, I'm under the impression it's his architectural office is located on site. I don't know, my client is here who may have a better understanding of what it is, but I don't believe anybody lives there.
I mean, the reason we're here for a use variance application, obviously, right? So whether or not there are other existing non-conforming uses is relevant.
That is relevant. Yeah, I agree.
Tom, I think from your notes, there had been a change to make it non-residential some time ago. You originally had residential.
So the history of the site, as far as I'm aware, there's a structure that looks like at one point in time had been a house. And within the last 2 decades, I believe it was rezoned into the C1 zone for professional office use, I guess. And at that point, my understanding is that residential use of the property had been abandoned and it was used as such. And therefore, to use it again for residential purposes would require use variance.
Joe Donato is the architect and we're told that's his office operating there, not his, he doesn't live there.
And what about the other office? Again, through the chair.
That is the astrology and I don't believe they live there. I have no reason to believe. They do.
Well, it's either a yes or, I mean, it's a simple thing.
I don't personally know the answer to that.
So then
but I-
who knows the answer then, sir?
Well,
If I may, for the record.
can you come forward?
Yeah,
please?
come forward. I'll get a little more rambunctious. Right. Okay.
And I'm gonna just swear you in, if you could raise your right hand. Do you swear or affirm that any testimony you're about to give is the truth, the whole truth, and nothing but the truth?
What's that?
I do.
And if you could state your name and spell your last name for the record.
Joseph Jacobs, Jacobs,
And just your address, please.
23 Wendy Drive, Linwood, New Jersey.
Okay.
I can state that no one lives at the property. It's used as an office. You have an architect and you have an astrologist. But no one lives there at all. It's not used as a residential home at all. It's used solely for an office.
So you have an architect in part of the building and you have an astrologer in,
Yeah, yeah,
in
that's
the
correct.
other part. Okay. And what are their hours of operation generally?
It's normal business hours.
Okay. And you guys, you have any questions, further questions for the?
No, the only question I have, but you're the owner of the property or the applicant?
I'm the applicant.
Oh,
Okay, so how do you have knowledge of what?
I've been inside the building and I've spoken to the owner. Many, many years ago, it may have been a residential property. The property has since been zoned commercial. No one lives in the property at all.
okay. I apologize. I thought you were the owner. My
No,
apologies.
no,
That's
no.
all.
Have you been in both offices?
Excuse me?
Have you been in both offices?
I have not been in the astrologist's office. I've been in the architect's office, but I've been throughout the building. And clearly no one lives there.
The only thing I'd like to offer to the board is what they're proposing tonight is for the billboard, and while the uses that may be going on there, they're stipulating that there's no one living there, then as Mr. Depkin's on, like, that becomes an enforcement issue. You're not, by taking any action on this application, if there is some use there that's not legal, you're not approving that tonight. So there is a stipulation on the record that there's no residential use happening here. Mr. Depkin certainly can enforce that, and any approval or action tonight would not approve any illegal use there. So just so you have some comfort.
I would just offer again that I appreciate that's what they put on the record, so it's on the record. But again, there's a use variance being requested, so that is the genesis of the question.
How is it binding if it's on the record, but he's not the owner?
Well, it's the applicant
Yeah, but
indicate, well, I don't know if it's binding, but the resolution would be binding.
But does the use variance that they're seeking apply to the use of the structure?
We will stipulate
It
that
does.
absolutely we are not seeking any use variance for the structure, for the existing structure.
That's your concern? Is that some?
Well, just to consider the totality of everything, because it relates to the parking and but
Mhm.
just to know what, not to make a mountain out of a molehill, but just to know what's there and what's proposed. That's it.
I mean, we have the zoning officer. I don't know if there's ever been any complaints about about this property.
We'll get to Mr. Depkin in a second. Let me just make sure Mr. Barron's concerns.
Again, I don't want to belabor the point,
Okay.
but that was the nature of the question.
Can't the owner testify? I mean,
The owner's not here.
I understand he's not here,
Well,
but I mean,
we could ask for
his application.
We could ask for confirmation, I suppose, at some point.
We can. Well, yeah, I think we can address that probably through testimony once we
Okay.
get to that point, assuming we deem the application complete at this point. So we have to take action on the other waiver request at this time.
Yeah, I would address waivers.
So Mr. Barron's has articulated the waivers. And I assume those are items that you would be seeking waiver from.
Yeah, we would, if there are requirements, we certainly are seeking the waivers from the board.
Okay. So is the board clear exactly on what is the discussion at hand, that there are certain things within the checklist that the applicant is not satisfied that may or may not be applicable to these applications? Then the request is being made that we waive those requirements to the extent that they do apply.
I'll give my I know I've been talking a lot so far.
right.
But I think at some point, whether the application proceeds or not, again, that question of illumination is going to have to be confirmed, given the adjacent uses. Again, the location and direction of illumination, because the borough has standards about illumination of property lines, so that has to be confirmed. And then finally, while billboards don't generate parking, I think having an understanding of the characteristics of the site as well as any existing non-conforming conditions is relevant to the application. Because I assume your planner is going to go into site suitability and whether or not there's a relationship.
I just want to be clear, we certainly want to provide testimony to all these items, and we're not asking for, them to be waived.
So instead of asking them for them to be waived, I think what you're saying is you'd like to be able to provide them.
To be deemed
And
complete,
your application.
provided not, not to waive them for the application material.
So can we conditionally deem them complete with those
Yeah, there-
obligations outstanding?
There's no, you,
There you go.
That's green, you're good.
You're good.
so there's no obligation to just grant all the waivers. And if you grant some of the waivers and want to proceed, you can condition it on them providing other items to your satisfaction. So if they don't address all the items you want in testimony, you can certainly have them come back and provide whatever additional items you want.
I mean, certainly the items from my perspective, and I welcome the board's input on. I mean, the items that Mr. Barron's has articulated, some of them I would think from my mind, what I heard are substantive in nature. So I would be comfortable conditionally approving, assuming we hear the rest from the rest of our professionals. But on this particular point, an obligation to supplement the application with the missing materials, I would think would be acceptable. But I open it to the board for discussion.
Why wasn't this provided in the first place?
Some of them we don't believe are applicable to this application, and that was our position. But if the board wants them, and they were brought up in the review correspondence, we provide testimony as to whether they apply or do not apply in this case, and how, we will try to address all the comments.
Let's come back to this. Why don't we go?
One more thing, because the survey, covenants, easement. I'm sorry. I didn't see the green light. You asked for also, you're saying none or not applicable. That's on page 18 of the checklist.
Yes.
For specifically to what, whether we provided a copy.
Well, reference to any existing covenants, deed restrictions, easements, exemptions that are in effect or intended to cover all or any of the site, copy of the deeds, copy of the covenants, easements, exceptions, so on and so forth.
I believe we didn't identify any covenants effect.
Here's the issue.
Mhm.
Survey from, if you read the notes, if you go to number 5, if you want to start at the bottom and work your way up, survey performed without the benefit of a complete title search and subject to municipal restrictions, easements of record, and other facts that a title search may disclose. So basically, your surveyor is saying, I don't know because I don't have the information. But you put none or not applicable.
I do believe, I do a lot of surveying real estate transactional work. That is pretty much standard on all the surveys, unless rarely are they provided with a full.
Do you have title work on this?
I believe our client did, and I believe there are no easements. We,
Well, it's simple. You need the Schedule B, right? You've done title.
Yeah.
Do you have the Schedule B?
I don't have it on me, no.
Does your client have the Schedule B?
I
No
don't,
title work?
I don't think he does. But I do believe we have looked at it and didn't identify any easements of record.
When was the title report, Ron? The title search?
I don't know, but it would, they go back for however long. I don't know. I don't have any reason to believe there's any recent easements or restrictions placed on.
As an owner of billboards, developer of billboards, and a lawyer representing billboard companies, I've been involved in probably a few hundred billboard applications in New Jersey, around the country. I've never once had a title search. The landlord in our lease has indicated that there are no easements or restrictions or anything of the like that would interfere with a billboard use of this property. So I'm proceeding at my own risk. The only time that I've ever had an issue, quite frankly, is with the state of New Jersey, which had a restriction, and they subsequently gave me the approval. That's the only time ever in over 100 applications that I've been involved in. So the owner has indicated that there's nothing that prohibits this use by way of an easement or restrictive covenant or anything of the like. It's me proceeding at my own risk, because if that were the case, then I would be harmed.
That's all well and good, if I may.
Yes.
But it's a requirement, again, it's a requirement under the checklist.
And I mean, if they don't exist, I don't know how we could submit them.
Well,
You could provide that
you,
schedule.
you
B,
can
though.
provide the Schedule
Schedule
B
B,
from a
yeah.
title which would show any of the easements. Your surveyor is saying he doesn't have it.
I think one of the one of the unique aspects of the property is its current shape, which resulted from not a taking, but a part of the roadway being absorbed by the New Jersey Transit. So that there is a history there.
NJDOT.
Right, that it's not an existing lot of record without prior impact. But we've heard the testimony. I guess the request is for the Schedule B, right, to confirm that
And that could be
there's
made a
there's
condition.
no issue.
Yeah, we can make a condition of approval. We'll provide.
Well, it's not up to,
Not a
it's up to this
condition
body.
of providing
Provide- yeah.
before they take action.
Okay.
So a condition of them deeming you complete. That's one of the items that they're especially flagging. In addition to the items that have been raised that they want additional testimony on, like the lady, for instance, that they may ask for additional documentation, but definitely the Schedule B would be one item that I think I can confidently say that's an item they'd want to have before they take action, so you could bring it for the next meeting.
Good.
Mr. Costa, anything further from your?
No, I think that's it. Thank you.
Okay. Mr. Depkin.
Yes, good evening. Thank you, Chairman. I agree with Mr. Barron's. I think the fact that this property is adjacent to a residential zone requires some more information. And on the item of occupancy, I can set up an inspection with my office to go and take a look at the property.
Okay. At this time, are you aware of any other uses aside from the uses that in terms of what's been presented to us tonight by way of testimony, the astrologer and the architect?
I don't recall receiving any information on this property. I think the only thing that we had was it in the C1 zone? I guess we don't have an updated map, and we went through that, and it turned out that it wasn't a C1 zone. But no positive or negative comments for that property that have been sent to my office.
Okay. All right. Turning to the board. Comments, questions?
It seems like these are things that can be provided, so we don't necessarily need to continue to have. Sorry, I'll start over. It doesn't seem like these are things that necessarily need to be had right this second. I know we've had lots of other delays with other applications. Do we feel that these are things that we can at least move on and get later, or do we really think that these are things that we absolutely have to start this entire application?
Worst case scenario, where they're proposing the billboard has some sort of a restriction. You can't put it there. They proceed. And next week or next month or the month after, they find out there's an easement, there's a pipe, there's something. Basically, it's a waste of your time as volunteers. It's a waste of their money because they haven't done the diligence to figure that out. They're saying they have, and they have it, but in essence, they don't. Now, you would think they would do their diligence. Their engineer would have done his diligence to make sure there's nothing there that would impact it, but they haven't provided the information. And from what I'm getting on the record, I know you did 100 billboards according to your testimony. But do we care about 100 billboards or do we care about the one billboard that's in front of the board this evening? That's the reality. I've seen a lot of things in my career. Where it is, I don't know. I know DOT has been working underneath that bridge right next to them for months upon months upon months. What's there, what utilities are there, I don't know.
Okay. Mr. Barron's, from your perspective?
Well, certainly we don't have enough information for the board to make a conclusive decision if the application were to proceed. I mean, we identified a couple pieces of critical information. And I mean, the applicant, but I don't know. I feel the onus, I think, is on how are you going to address these outstanding items and in the course of your presentation?
We could we will, if we were allowed to proceed tonight, the board does not have to vote. We could come back and provide you with the information that was requested, but I do believe some of this stuff will certainly be addressed through testimony of the engineer.
I'm just looking at it that we're all here. If it's not terrible that we proceed tonight and not go home and start over in 2 weeks, if they have to come back in 2 weeks and say they weren't able to comply with what we need, then we don't come back in 2 weeks. Just generally how I'm looking at it, if it's something that's not, that we can at least wait for answers for. It's just, so we don't go home just to do this all over again.
And that's fair. I would just request any information is provided with ample time for the board and professionals to review and make an informed opinion on.
Yeah, I from my perspective, I'm inclined to, if we can, get them complete, conditioned upon supplementing with the missing information between now and the next meeting for us to begin to look at this,
Yeah, I mean, I do know the easement stuff will be easy, that will be quick. There either are or aren't easement. If there are, then we could call back and show where they are and describe what and give testimony about such, but we don't believe there are any.
I think given the time constraints, like the sooner you get any information provided to the board,
absolutely.
then they could start reviewing that.
Mr. Craig?
Yeah, I don't want to make this simple if it's not, but unless I'm utterly mistaken, completeness review is for us to have all the information we need to be able to make a decision. That doesn't exist. So how do we sit here and say your application is complete when in fact it's not? I mean, that's pretty simple. If it's not, tell me what I'm missing.
I'll go a step further and say that this is not the first applicant. It's not your fault, but it's not the first applicant that comes before this board with incomplete paperwork. And then we're left to say we're going to waive it and we'll come back and we'll get it later. But, 2 weeks or a month or 2 months later, you start forgetting this stuff. It's better. Like I take time to review all this stuff beforehand so that I'm prepared and I can ask questions and I can listen to everything that's going on and be able to make a decision. To say to me, you're going to get part of it now and part of it later, and we'll try to find it, and then maybe we'll change things around if it turns out that it's different than what we thought. Just seems like a waste of our time, but I'll do what the board wants. I'm
I have
here.
a question. So everything, like say Article 5, right? So the items, the checklist items, when you say none or NA, right? So to the extent that the applicant feels that it's not applicable, wouldn't they have the burden to establish the reason why it's not applicable? Right. So it's not just because we don't want to assume that you're just going to fill in the blanks, right? If there are certain things that are not going to be applicable, though, we're going to need a thorough enough explanation, right, as to why they're not applicable.
And maybe it would be helpful to go one by one.
Yeah, maybe.
If you want to address each one and provide the testimony, if they don't feel it's sufficient, then it's not sufficient, but that might be helpful.
At least we can figure out what
Which ones they want.
Yeah, and they're not numbered. And the identification didn't have to do with whether or not they were identified as yes or no, just simply whether or not they were actually prepared or not. And so beginning on page 13 of your application, I'll wait till you get there. It's top says River Edge Land Use Board checklist site plan. It's I think page 14 of your application packet.
14, okay.
It says 13 on the bottom though. I'm looking at a PDF.
Oh, okay, yeah, yeah.
14 of 43. Let me know when you're good.
I'm here.
All right. I'm just going to skip around the best I can because again, these are not numbered. First issue identified had to do with the use. And I will get to it. It's not on that first page. I believe it's on the second page. Bear with me while I. Zone boundaries. Number and type of proposed uses to occupy the building. I think that could be translated to mean site. That's in the middle of what's page 14 of the checklist. That's where one of the use questions come from. There is then, bear with me. It has to do with the parking was the second one I identified. I'll go them in the order that I come upon.
Which page you on, just so.
So page 14, in the middle of page 14 of, it's numbered 14 at the bottom.
Okay.
Checklist. In the middle, it says number and type of proposed uses to occupy the building. Granted, this is a billboard, but I think that means site in the context.
That would be in our mind, it was the billboard is the building. I get it. We could provide testimony. We believe we could address that through the testimony.
This is just super technical. What's been provided, what hasn't been provided. I'm not taking a position one way or the other. I'm moving to the next page now. Location. We have the location toward the bottom of what's labeled as page 15, location and direction of all illumination and time of proposed outdoor lighting, including all standards and utility poles on abutting streets. So I think the location direction of all illumination is a critical component of the, again, potential spillage to residential properties. Again, recognizing that a lighting professional had done a study, but it's kind of in a vacuum because there are no property lines. So we have an ordinance that requires a maximum lighting threshold at the property lines. I think I don't know if it's 1 foot candle or 0.1 foot candle, but that could be a compliance question. Moving along, I am now on page 16. I'm just cruising through to see where we are here. I did note locate transformer. I don't know if that's applicable. Do you guys need a transformer at the base of the billboard? No. Okay. Moving on. I'm on page 17 now. I'm skipping to page 18. 18, item F, description of the current uses of the property. Okay, so not building, but the property. Item G, complete and full details of the uses of the site.
I'm sorry, you said FNG?
FNG on page 18 of the application. We also then have item J on page 18, which is that reference to existing covenants, deed restrictions, easements, etc. We addressed that. You indicated that as not applicable. We have. I'm sorry, this is so painful. I did not intend this. We have item S on page 19, which is reference to the number of parking spaces required for the proposed uses by ordinance and the number of parking spaces proposed as part of the site plan. Again, I understand billboards don't require parking. There's a question of whether or not it actually impedes into the parking area. And again, just an understanding of existing non-conforming conditions to the extent that there are any. I had the question about Bergen County. I'm on the next page now. Sorry. Page 20, item U, Bergen County site plan approval. I just don't know the answer to that question. If county site plan approval is required. I'm moving on now to page 21. Nothing that I see relevant, so I'm going to move on to page 22. In the middle, item number 12 on page 22 is number of parking spaces required by ordinance. number of parking spaces provided on subject property. Moving on to page 23. And item number 3 pertains to easements. Item number 4 pertains to underground utilities. Item number 2 on page 23 talks about existing and proposed contours for a distance of 30 feet around the perimeter of the property. So page 24 is just some engineering, drainage, runoff calculations that may not be relevant. I'm on page now 25. Simply landscape requirements, and obviously there's no landscape plan. You're not proposing any, but it's a technical requirement, and you wrote yes down the box there. Granted, you did show what's existing as far as trees on the site, but just the mere fact that there's nothing proposed, you're entitled to request a waiver. Okay, I'm on page now 26H. A comprehensive and accurate lighting plans, including the proposed location, direction of illumination, power, and times, the proposed outdoor lighting, etc. Well, I'm on page 27 now. I believe that's the extent of what I have. That's it.
Mr. Costa, do you have anything to add to the list?
No, I think that's it.
Okay.
We talked about basically parking, use, easements, and lighting.
Okay. Mr. Foster, how would you like to proceed? Do you want to try to address these items one by one? I don't know at this point if you can, given the technical nature of these things, but at least give you a shot to do so before the board.
Certainly, however, whatever is the bit easiest to understand, maybe it is better to go item by item.
Well, I think in fairness, I'll give you a shot to try to address these things, but you know, there's a fairly substantial list here of items, and in fairness to you and fairness to the board, needs to review these items. You know, we'll give you the chance to try to address them, but like I said, before the board makes a determination on completeness.
We do believe that the use has been ironed out, that there's 2 commercial uses at the property, and that we would, you know, we certainly, we don't have the owner here to give you the exact testimony, and we could bring him back at another date to confirm that, but it is our understanding that that is the use, and it's been represented as that, and we're not changing in any way, changing that use. And I understand the board wants to be clear on that, and we can give testimony from our planner and engineer who've been to the site and would be able to know that the use, and there's no reason to believe that it's not. The parking, we were going to show, you know, we have our engineer here who could testify as to the parking is, the conditions, whether the billboard would affect the parking, and that was going to be done tonight through his testimony. Now, the survey, we represented that there's no easements of record, and I can't provide to you Schedule B tonight. We certainly could come back with that and go over it, you know, at the next meeting, but we think we could proceed on it. And in the event there was something restricting it, it's the applicant's own risk, and we wouldn't proceed with the application. And the county site plan approval, I believe our engineer could testify to that.
The other big ticket item was lighting.
Lighting, which our engineer was going to testify to.
okay.
I believe the lighting, we did provide it. Now, whether, I understand you don't believe that it's sufficient, but to be clear, we did provide a lighting study. There might not be property lines but that, when we got to there, we could, give testimony as to that.
Okay. All right, based on the information we've just heard, questions from the board? Wise, I will ask for a motion on
I have one thing.
Mr. Codier.
So as I see it, I mean, the major issue here is the lighting study may be incomplete. As I see the whole process of a completeness review, why even do it if we're not going to adhere to it, right? So I would ask our professionals, do you feel that this application is complete?
Well, it's not, it's not complete. And that's why they either need a waiver or they need the board to say, thank you very much. Provide the information and come back and we'll deem you complete. It's up to you guys. It's not up to us. There's one little caveat that I might have slipped out of as far as the parking, Mr. Chairman, members of the board. A portion of the pavement that's used for parking isn't on their property. I don't know if you know that or not.
We do.
Yes.
But there's no proposal to remove that and what that causes.
Correct.
This board can't approve a plan for parking that's not on your property.
We're not proposing parking on that. We're not proposing parking.
Well, it exists. There's an encroachment on the plan. I don't know if, like I said, I don't know if you knew that or not.
We did.
So they're using it though, right? The tenancies are somebody's using it. You want me to go a step further? If you're using it, somebody asked me this question in Saddlebrook many years ago when they put bricks underneath Route 80. And somebody called and said, well, where do we do the 200-foot list? I said, it's Route 80. It starts in New Jersey and it ends in California. I said, I would start there. My question is there a jurisdictional problem?
Speak to that as far as if there is an easement and you're using that and it should include that property, then you would go from that portion if it's like an access drive or like parking. So
It's not, just for clarity, it's the right of way. That's.
Yeah,
The
likely,
license
it was
agreement.
likely taken at some point.
Well, right. I'm just clarifying. It doesn't
Yeah.
seem to be an easement. It's actually physically a lot that's part of the right of way owned by NJDOT. I think that's that triangular thing we're talking about.
Well, their parking lot sits on it.
Well, right. She mentioned easement.
So-
so you're saying if it's a lot that is being.
No, again,
So it's a separate lot that you're talking about?
I'm not on that side of the dais. I'm on this side.
No, I'm not.
It's like a slice out of if you look at the survey, it's a corner that was likely at some point, the state probably or highway authority took it for the
You were
right.
asking about whether that entity would have had a consent to the application
Possibly.
and then.
And jurisdiction
Yeah.
and,
Well, it's not depicted on we're not proposing anything in that area.
no, it exists. You're using it. You're using it.
The owner may be using it, but it has nothing, it's not.
Yeah, but
we're not
you're asking for a use variance application. How do we consider this as a board in isolation of the totality of the existing site conditions? That you're asking us to forget everything else, look at the billboard and
No,
just
but
look
it's-
at.
Yeah, it doesn't work.
Well, no, but we're not we're not utilizing that for parking on the site.
You have, if this, however it gets approved, whether it gets approved here or somewhere else, you have then three uses on this particular piece of property from what you said earlier. You have the architect's office, you have the astrology office, and you have the billboard. And we've gone over it in another application. Someone has to show up. It's a static billboard. Someone at some point in time has to show up and change the signs, do some maintenance. So you need some sort of parking for that individual. I'm not saying they're coming there every single day.
The entire parking lot is not in that area.
No, it's not, but a good portion of it is.
But yeah, we were gonna provide testimony as to the
But
parking.
there's no, the board can't The board can't approve a plan that shows parking on someone else's property.
I mean, we're not utilizing that. I guess what,
Maybe you don't understand where it is. You are utilizing it. You are.
Or can I just speak on behalf of the applicant?
If I could just swear you in,
Sure.
if you could raise your right hand. You swear or affirm that any testimony you're about to give is the truth, the whole truth, and nothing but the truth.
I do.
And if you can state,
yeah, just you.
You don't have to turn that one on.
if you could just state your name, spell your last name, and give your business details for the record.
Sure. Good evening. William R. Vogt Jr. Last name's V as in Victor, O, G like girl, T like Tom. I am a licensed civil engineer who created the site plans for the application. I'm one of the principals and owners of L2A Land Design LLC, and we're located at 66 Grand Avenue in Englewood, New Jersey. I've appeared before this board on multiple occasions on multiple applications.
Yeah, can you give the board your qualifications, please?
Sure. I have a bachelor's in science and civil engineering from SUNY Buffalo, and I'm a licensed professional engineer in the state of New Jersey as well as New York, and my license is in good standing.
Okay, have you appeared before this board before?
I have.
Okay, any questions from the board as to Mr. Vogt's qualifications? Okay,
Sure. Yes, we are aware of there is a triangular piece of property. I believe it's designated as lot 5.01. That is part of the DOT right of way. It was part of their taking when they improved that intersection. We are not proposing any work on that portion. I do understand that they are utilizing it as parking. I did try to go back through some historic photographs. It looks like parking has been in that area at least back until 1985. It was striped at one point. What I could tell, there was roughly 7 or 8 parking spaces shown on that rear portion of the property or to the west. I don't have any evidence that there's any easements granted to the owner of the property to utilize that portion of the property. I can certainly have my surveyor do a review title and see if any easements exist in that portion. But for the remainder of the site, we're unaware of any easements or restrictions or DOT restrictions on the property.
That does cause me some concern, just if that property is part of this application, if there should have been some sort of consent or so that's from my perspective is the only thing that kind of is a concern to me. Because I don't want to get down the road and then not to have jurisdiction. So that's your main issue. I know you're not utilizing it, you don't need the parking, but if it is part of the application, that's the only thing, for your attorney that I'm raising as a concern.
I mean, it's not actually part of our application.
But it's used on the site for the other uses in the park.
Right. No, I understand. If they're using it and they're not allowed to use it, then yes.
Yeah.
Then we would have to remove it. I would agree. There's
No, I think you're missing the okay. Let's start over.
your mic's off.
You have an existing.
Your mic's off.
We got to put the green on the bottom. We have an existing tenancy, correct? 2 tenants that they don't fly there and get dropped off and helicopter in.
Correct.
They drive there, right?
Correct.
We heard earlier, we're not sure how many.
2.
2 tenancies. We don't know how many employees because the information wasn't provided. Okay, we know that, right? Unless you know it. It's either a yes or a no.
I know that there are 2 tenants there. One is Joe Donato, who's the owner of the property, and that is his sole business as an architect. He is the only employee that utilizes his office. And there is an astrologer that
Okay.
runs that.
So let's say there's
business.
3 cars, right? It would be 3 cars.
That would be 2. There's
Well-
2 people.
Well, if somebody goes to either one of the
To
offices,
change,
maybe not at the same time, let's say a minimum of three cars, I would think, 3 or 4. If a portion of the property isn't on your property for the parking, how do you use the parking on someone else's property if you don't have easements or covenants or license agreements?
I understand that. But what I'm representing, if they're not allowed to use that portion of the property through any easements, then we would need to restripe the parking compliant on what is left.
All right, let's start again. You either remove the encroachment and you have all of the pavement on the property
I think
you
I
own,
stated
be
that.
simple, you own it. That's what you could utilize, and you would have a parking plan because you're gonna have possibly three different uses, right, on the property. You can't use the parking that is on someone else's property unless you have an easement to do so or a license agreement. But again, that creates other issues because that might not be in perpetuity. And that could mean where this board would have to say, okay, but if that gets taken away, it affects the overall use of the property. And then you need to either come back here or lose the use. So it's important.
I will say
Understood.
If they're stipulating that they're gonna remove that pavement and not use it whatsoever and restripe, then that would get rid of my
Your
concern.
problem, right?
So
Correct.
from my perspective, maybe not your concern.
That's the avenue I was looking at it as. If they cannot use that portion, we would have them remove it and then restripe the parking lot to be compliant.
But if,
But
that's
if you're
not-
not the owner, then you can't say that.
Absolutely, absolutely. I'm just being
Yeah.
logical as the applicant's professional. If they're not allowed to use it, then I gotta fix it for them.
And that is the base of our application saying it's not, part of it, but we understand that the concerns and if the parking was not allowed, yes, it would have to be moved onto the site. But we're not proposing, our application doesn't, it's for strictly for, deeming complete, that's our position.
But if you don't remove it, you don't have, possibly the board doesn't have jurisdiction. You didn't notice correctly and you don't have the consent of an owner to file you can't file an application on somebody else's property without their consent, Counselor.
I mean, we are not I don't believe our notice would be defective. We would have noticed everyone.
The board can't approve a plan showing parking on someone else's property if it's not legally existing.
Are we showing parking?
You are. You're showing the pavement.
There's curb stops
There's curbs
on the NJ DOT property.
There's clearly asphalt beyond the property limits as shown on the survey
What currently exists.
that currently exists and if you go back through historic photographs, at least to 1985 is the farthest I could go back, and I saw the same parking configuration on the property. So it's been there for decades. Whether or not during that taking of the DOT right of way, they didn't enforce them to remove the parking that was in that portion of lot 5.01, or it just no one ever got around to it, or I don't know the history of it.
All right.
And my concern is not that it's a pre-existing condition. So if there's any sort of, if it encroaches on the setbacks, let's say, I don't care about that portion. I care if it is being used and it should have been kind of part of this application, even if you don't need it for parking, if it's being used for parking, then I think it raises whether it should have been within the 200-foot encompassed in that. And I don't want to get down a rabbit hole.
Well, definitely, it's right. I mean, it's right there.
All right,
Yeah.
so at this point, we're hearing a lot of, we think maybe this is what we know, we're not sure we know, maybe this applies, maybe it doesn't apply. There sounds like there's a little bit more homework that has to be done here on your part. And, I'll defer to the board for, determining completeness. But at this point, from my perspective, what our
Well,
professional
let's go back in time. Somebody got up and said, there's no easements, there's no covenants. Now we have an encroachment on somebody else's property. So if we go back to that point in time,
That,
then it's not lawful.
well, that goes into, there's some homework that has to be done here. Okay, clearly. So at this point, what I would like to do is I'd like to take a vote on completeness. I think unless you guys have anything further to provide, but I think you're.
I mean, we just want to put on the record that the Costa Engineering Report does deem us complete, and we respectfully believe that was correct and accurate on page 6.
Okay, well, we have other professionals too who've got
Yeah.
other issues, so,
It would be a recommendation maybe.
Yeah.
Because we don't have the authority to deem complete.
Yeah.
That's just putting it on the record.
Mr. Depkin, anything from your perspective?
No, Chairman.
Okay. All right, so at this time, I think what I'd like to do is I'd like to have a motion to determine completeness of the application.
Do we have to say that we're deeming it complete, or can we say we're deeming it incomplete?
It's a motion for either.
Motion for either.
So I would make a motion to deem that it is incomplete.
All right, so Mr. Gibbons is a motion to deem the application incomplete.
Second.
All right, I think I have Mr. Salva on a second.
Okay, Chair Caseland,
Yes.
Mr. Cray,
Yes.
Ms. Boland's absent. Mr. Gibbons,
Yes.
Mr. Chininga,
Yes.
Mr. Salva,
Yes.
Mr. Goudier,
Yes.
Ms. Levine.
Yes.
Okay. All right, motion passes. My recommendation is, I think there's some more homework that has to be done. Certainly, we would encourage you to reach out to our professionals and compare notes with them.
We just would like, I mean, we thought because of the recommendations that, there weren't outstanding issues and we could have been in a better position to address them tonight,
Well, I think there's a combination of things. There's a combination of things that I think you can address through testimony, but clearly there are other things that the documentation has to also present for us to.
No, fair enough. I just saw
So-
we were provided, it said we recommend deem complete, and then we got here tonight. We want to address the issues. It's
Okay.
not, we're
All
not,
right.
not being confrontational. I just wanted to make sure that we didn't think these were going to be issues. Otherwise, we would have, been in a better position to
Okay.
address.
No, fair point. Okay.
Next.
What is your best guess for addressing these items
Should be pretty quick.
time-wise?
Yeah, when can we get on the next hearing? Or when is the next available hearing? And when would you need documents before that meeting?
I mean, I'm gonna recommend at least a week in advance, 10
Next
days.
meeting's the 25th.
Next meeting is the 25th. We have one application on that.
Yeah, I mean, you're required to, obviously, any new information is
Yeah.
required 10 days prior to the hearing. For the public to look at it.
Could we just be put on that and in the event?
And then if you want to adjourn.
Yeah. Do we have, with this on the 25th?
Property.
Do we have space in the agenda on the 25th?
So you would need documents submitted on the 13th or the 16th. I just want to clarify the date. Well, 10 days. Does
10
that
days.
include weekends? It's just 10 physical days,
It's 10,
correct?
10
Okay.
calendar. Well, that's why I'm asking the question, because it's not an easy,
Well, it's either 3 days or 5 days, whatever
I'd say the 16th.
Monday.
you need them by Monday.
I mean. It's possible, it's not possible.
I mean, let's look, we'll put you on the agenda for the 25th. If you make the 16th, great. If you don't,
Do you have
then
anything else on the 20th?
If not, we'll let you know well in advance that, to request to carry it. so we don't-
The only thing, if they don't have anything on the agenda
we don't have anything on the agenda for the 25th.
and they cancel, then you'll have to renew.
Well, yeah,
We,
yeah.
we do have an agenda, on the 8th of April. So just.
But they may work.
It's either 3/25.
Let's just do the 8th, if that's what, we don't want it. just so, because this is really tight deadline that we just want.
We've got another agenda item on the 8th. So,
Well, maybe we submit it and,
if you want to submit it, we'll see if we can get John.
yeah, and maybe, we could be deemed complete at that hearing, and if we understand you have something else.
That's
at least.
right. I think that
Makes sense.
well, that makes sense. Okay.
So with that, I'd like to announce for anyone in the public that this matter is being carried to the April 8th, 2026 meeting with no further notice being published or mailed.
All right. Thank you, gentlemen.
Thank you.
Thank you.
All right. At this time, we have nothing further on the agenda. Questions or comments from the board, professionals? Otherwise, that being said, I'll look for a motion to adjourn.
So moved.
Thank you, Mr. Gibbons. Is there a
Second.
I think I have Mr. Gardy as a second. All in favor?
Aye.
Any opposing, abstain? We are adjourned 8:48 p.m.